What if tomorrow your business fails? You get sued, or the bank wants to take everything you own. Did you know millionaires keep 5 types of assets that bankruptcy courts legally cannot touch? This isn't some shady loophole. It's completely legal. And the rules change depending on your state. Most people don't learn this until it's too late. Today I'm going to show you those 5 things. Plus one secret tactic almost nobody talks about. This isn't random advice. It's based on federal bankruptcy exemptions and state-specific asset protection laws that real lawyers and financial planners use for wealthy clients. I study this stuff because asset protection isn't just for the rich. It matters just as much for regular families. First, you need to change one belief. Thinking everything I own is mine is actually what puts you at the most risk when a lawsuit or bankruptcy hits. The court doesn't care how much you earned. It cares about whose name the asset is legally under and how it's structured. Millionaires personally own very little. Their assets sit inside trusts, retirement accounts, and legal entities that protect them. Here's the mindset shift. Ownership and control are 2 different things. Until you understand that, nothing else in this video will make sense. But what I'm about to show you next, this is the part people usually skip. And it's the most important one. This is the system every financially smart family follows. Categorizing your assets correctly. Retirement accounts, 401k, IRA, under federal law. These are protected from bankruptcy up to certain limits. Homestead, exemption, a portion of your primary home is protected. And this amount varies wildly by state. In Texas and Florida, it's basically unlimited. Life insurance cash value in many states. The cash value inside permanent life insurance is protected from creditors. Structured annuities. Certain annuities also fall under exempt categories. This system works because the law itself labels these categories as protected. You're not doing anything illegal. But what I'm going to tell you now, this is the part almost nobody knows about. Here's the specific tactic. Tenancy by the entirety. If you're married and live in certain states, like Florida, Ohio, Delaware, or Michigan, you can hold property jointly under tenancy by the entirety. This means if only one spouse gets sued individually, say for a business debt or personal guarantee, the creditor cannot touch that property. Legally, the property is treated as owned by the marriage as a single unit, not as 2 separate owners. Almost nobody knows this because it's not available in every state. And your deed needs specific wording to qualify. Otherwise, it defaults to regular joint tenancy, which does not protect you. Do this one thing today. Google your state's name plus homestead exemption 2026 and find out exactly how much of your home is protected. That's it. 5 minutes, and you'll know exactly where you stand. Now that you know what bankruptcy can't touch, the next question is, what can't the IRS touch? Because IRS rules are completely different from bankruptcy rules. In the next video, I'm breaking down the 5 assets the IRS legally cannot seize either. If this helped, follow so you don't miss it.